Welcome, welcome to Defense Diaries. I am your host, Bob Mata, and I will soon be joined by that kind of blank circle right now, but what will ultimately be filled with my beautiful, brilliant co-host, Ali Mata. I don't know where she's at, but she'll be here intimately, or not intimately. That was a Freudian slip. Immediately. So, what's up, y'all? It's been a minute. Oh, there she is.
Your dad wanted to watch, so
Oh, okay. All right. Welcome, babe. Good to
hi.
see you.
Hi, babe.
So,
Hi,
so we're
all.
back. We're back from London. Had a spectacular trip out there. A roaring success. We did CrimeCon UK and then spent just under a week exploring the incredibly magnificent city of London. Just blew my mind. It was my first time out there, Allie's first time out there, and we were just blown away on just how magnificent that city is. It's a whole different vibe. It's a whole different vibe than the US. Anywhere in the US, I've been all over the US, and there is nothing that comes close to
Taking
London.
my earrings out.
There-
Sorry.
there's just nothing that comes close to London. So, all right, tonight what we're going to do, we are going to give you what we consider to be a bit of a trial primer. We're not so much going to go through
Oh, trial
factual
prep.
things. Yeah, trial
You
prep. Just
saved your primer for your primer.
yeah, the primer will be the primer when we are getting ready to start the trial, which is slated to start in just a couple of weeks. Couple of weeks.
Speaking of which, we were just talking to Melanie. Um,
Little.
right, and I was just blanking. Is that the name of her channel?
I think so. I
Sorry,
think it's
Melanie. Who is also a lawyer and also, I'm sure many of you know, has a YouTube channel, and she's gonna do the primer with us and be the voice of the people because she doesn't know a lot about the case. So she'll have a lot of educated lawyer slanted questions, but that address the things that not everybody knows. So that should be fun. We're gonna do that.
yeah. I'm excited about that, and it'll be great. She was knee deep into Karen Reed's case, so that was pretty interesting.
Oh yeah, it's attorney Melanie Little. That's the name of her channel.
Okay. Yeah, I didn't think she had like a name of it
Right.
like we have Defense Diaries here. So, all right, before we get started with that, a couple of things that I wanted to put out there. First of all,
Thanks, Leah.
I think that there's probably a lot of our subs that are not able to view this with us tonight because they probably still do not have power. To all of our friends and fam down in uh, the southeastern portion of the United States who's just going through absolute hell right now, who've just gone through absolutely life devastating effects
Yeah,
from
our thoughts are
Hurricane Helene. Yeah, it's been
with
on
you
like
guys.
the flooding after the fact. It's been unbelievable. So our hearts and thoughts are going out to all those
Stay
folks.
safe. Stay safe.
Yeah, like we're thinking of you. We really are. We hope that you guys are taking care of yourselves, taking care of each other, and remaining safe. I hope that you're able to get relief for the devastation, the loss of property, everything. It's just unbelievable, just terrifying. I had little to no idea what was going on because we were in London, and believe it or not, they don't really give a shit about the United States weather patterns so much until something catastrophic happens, and then they'll start reporting on it some over across the pond, but it certainly wasn't
Well,
a
we also
main.
weren't paying a lot of attention
No,
to
we
it.
weren't. I was very much trying to stay off the grid, and just focus on spending time with Allie and my family, which we did. We had a magnificent trip. But so our thoughts are really with you guys, and our hearts are going out to everybody that's down there and is affected. So um, yeah, it's a devastating thing. It's really it's heartbreaking, truly. So the other thing that I want to mention is we're also coming very close to the Berkshires Podcast Festival, which Allie and I are both attending And that is the weekend of the 18th through the 20th. I'm actually going to have to miss the Friday of the trial, which is brutal. But I've committed to doing that. And I would never bail on my buddy Josh Hallmark and his amazing podcast, True Crime Bullshit. So Allie and I will be out there for that. I'll be there for openings. But you
We are
know,
gonna leave earlier than we planned so that you can be
yeah,
back for Monday.
yes, yes, yeah, I'll be back. Hopefully in the courtroom. But that's one of the things we're going to go through tonight. This new courthouse management decorum or order dropped. So
It
yeah,
said,
we
"No
love.
Bob Mata allowed."
Yeah, it said no. They aced me. She finally did it. No,
No.
she didn't. I didn't make the order, which is good. That's good. I knew I was okay as soon as I was fine getting in on the 3 days of hearings. I knew. Um, she was wearing her big. What's up, T? We miss you too. We miss you too. Um, so I think what I want to do first is we always kind of assume that everybody knows kind of the background of this case, and I think that that's the wrong thing to do. I think that what we need to do, I want to give like a very brief summary of the case, the investigation, what happened, and then we're going to jump into what we believe that you can expect at trial. So here we go. On February 13th of 2017, Abigail Williams, age 13, and Liberty German, age 14, had the day off of school. And the girls had made arrangements with Libby's sister, Kelsey, and her father, Derek, to drop them off and pick them up from the historic hiking trail in Delphi, Indiana. February 13th was the unseasonably warm day, and the girls were dropped off at around 1:35 p.m. by Kelsey. The Monon High Bridge, which is an old railroad trestle that allows trains to cross back in the day, Deer Creek, and it was a popular place for teens to gather and to take pics for their socials. And at around 2:07 p.m., Libby posted a photo of Abby walking the bridge, and this sadly was the last contact of any kind that either of the girls ever had with the outside world again. And at 3:15, Libby's father was at the trails waiting for the girls to meet him as scheduled. The girls never showed up. Text messages and phone calls went unanswered. As opposed to immediately panicking and calling law enforcement, I think they did what most parents would do. They started putting out calls to friends, family, local, find out if the girls had made their way over to their houses themselves.
That's what I mean, I would have tried that first. Your mind just doesn't go right to worst case
Right.
scenario.
No, I mean, you're always going to try to call friends, family, see, like if you heard from the girls, you're going to not immediately assume the worst. You're going to be irritated and initially, and then it becomes fear, and then it becomes panic. So by 5:30, the family knew definitively that something was wrong, and they called and reported the girls missing. A massive search of the area by law enforcement and local citizens went into the early morning hours of the 13th into the 14th before getting called off. The search recommenced early the next morning. Sadly, the girls' bodies were discovered about a half a mile from the high bridge on the north bank of the Deer Creek, on the property of a man named Ron Logan, which abutted the trails. It was evident from the scene that foul play was at hand, so the search for suspects began immediately. On February 15th, 2017, law enforcement released a still photo of a Caucasian man in blue jeans and a blue jacket wearing some type of head covering, a hat, with his hands jammed down in his pockets. Shortly thereafter, this man became law enforcement's main suspect and was referred to as Bridge Guy. So on February 22nd, law enforcement released a short video that had been captured by Libby German on her phone, wherein the audio captures Bridge Guy apparently saying the words "down the hill." So on July 17th of 2017, law enforcement releases a composite sketch of what they believe Bridge Guy to look like. That composite was created from various witness accounts of a man that various people saw on the bridge that day. Fast forward to April 22nd of 2019, and that gentleman in the 2017 sketch of July looks to be middle-aged, probably early to mid 40s.
Do you think it looks like relatively like Richard Allen?
No, but I don't think any of the sketches really look like Richard Allen independently.
Right.
So on April 22nd of 2019, a second sketch is released by law enforcement, and this sketch depicts a much younger looking man with no facial hair. At that press conference, law enforcement essentially comes forward and says, "Look, we think that this guy's hiding in plain sight, and we think that this person probably lives in Delphi. We think it's a resident. We think that it's somebody that was familiar with the bridge, familiar with the trails." So,
Am I right in saying that we now know that they had abandoned thinking it was that first older gentleman and moved on to this younger guy?
well, it depends on who you ask. If you ask Jerry Holman, he will sit on the stand, and he did during the 3 days of hearings and said, no, he thinks that they're the same person. So ultimately, this case goes cold. They looked at Ron Logan, whose property, as I said earlier, the girls were found on his property. They went so far as to securing a search warrant, searched his properties, searched the land, and ultimately he was never placed under arrest. The investigation then led them years down the road to a gentleman named Kagan Klein and his father, Tony Klein, but mostly Kagan, who was believed to be operating a website or an account by this guy, Anthony Schatz, which was a catfish account that was used to had a picture of like a model kid, some attractive young guy that was communicating with all kinds of people. Ultimately, they end up not arresting him either. Fast forward to October 20 of 2022, a man named Richard Allen is arrested. And from that point forward, that's where our coverage in this case really picked up. And the procedural posture, and I'm not going to go through that here because we've been going through it since it's been going on. You can just watch all of our old lives. And it's been a nightmare. It's just been an absolute nightmare. If you're looking at it objectively, um, without taking sides, if you just look at it from an attorney's perspective, procedurally, it's been an absolute nightmare of a case, how it's been handled by the judge, specifically early on, especially. I mean, things have seemed to settle down at this point. While I obviously am not in agreement with many of the things that she's elected to do in terms of her rulings, at least she's just got this thing moving at warp speed towards trial. So,
While you're talking, I'm gonna share Sleuthy's images of the people.
right. So the bottom two. So the bottom left
Oh, sorry.
is, yeah, just keep it how you had it. It was perfect. So
Okay.
the bottom, what's my bottom left was the first composite that was put out by law enforcement. So you got the kind of the Irish or English hat, little facial hair, looks like a stubble of a goatee, little
Oops,
longer of a
sorry,
hair.
sorry.
Why do you keep messing with it?
I
Just
didn't
leave
mean
it.
to. Is that can you see it or I need to make it
No,
thick?
it's perfect. It's
Okay.
perfect. Don't mess with it anymore. It's good. Don't don't mess. Everybody can see all four. So then 2 years later, in 2019, you've got Betsy Blair, the person that she saw on the bridge. And to me, obviously, they look like two completely different people. They look like two completely different aged people. The one isn't wearing a hat. One doesn't have facial hair. One's baby faced, looks to be early 20s, if that. I mean, that kid could be 17. I don't know. It definitely doesn't look like a 40-year-old overweight, you know,
Is
pudgy
Sleuthy out
dude.
there?
Yeah. Um, and then we've got two other sketches here that kind of came out. Now, they weren't released in the same way with press conferences, the way that the bottom two were. And as I said, what ends up going on with the two sketches ultimately, as late as August of this year, you have Jerry Holman getting on the stand and saying, "Look, I've always thought these are the same guy. These are the same dudes," because that was always an issue. You know, people were saying, "Oh, well, you had us looking for this other guy. Now, like, which is it?" He's like, "Well, it's not a which is it proposition. What it is they're the same person, just from two different witnesses' perspectives." So ultimately, as I said, the sketches didn't really help in terms of getting anybody nabbed. I don't. The sketches weren't the thing that got Richard Allen arrested. I mean, there's obviously been photographs of Richard Allen in a local bar that had the sketch up that was like right over his right hand shoulder. I know that the CVS had the sketch up, and he was, a pharmacy tech there. So, I mean, theoretically, he's standing there, in front of the sketch for years, and no one puts it together that it's him. So, but ultimately, what did lead law enforcement to making the arrest is ultimately they had found a unspent casing in between the girls at some point during the search. It's been speculated about quite a bit as to when it was found. It's another one of the things I'm just thrilled that trial's coming so that we can get actual knowledge instead of people speculating about everything. So ultimately, that was found by law enforcement to be a match to a weapon that Richard Allen had in his possession that was found during the search of his home post arrest, or no, pre arrest. So then ultimately they end up uh, using the fact that he's at the bridge that day. He had volunteered the information to law enforcement either the day of or the day after the girls went missing. The argument being there is that people that are like, oh well, he didn't know there was going to be a video of him, so he was just going to law enforcement to get in front of it, be like, oh yeah, I was out there, not having any idea that there was this video that existed. So and then it backfired on him. Those that are in the he's not the guy camp are like, oh well, I mean, who puts themselves on a bridge where two girls go missing and are ultimately found deceased? Like who, like, that's not something that killers typically do, put themselves at the scene. So I mean, it can be argued both ways, obviously. So and that was essentially it. And you had a few eyewitnesses, four eyewitnesses that gave varying accounts of a person that they saw on the bridge. All of them somewhat different in terms of height, weight, what they looked like, and none of them, in particular, really struck me as being Richard Allen, in the sense that my estimation, and this is just me, but whenever I see a man that's 5'4", like I've got Wally's 5'6", Allison, one of my best friends, and he's a short guy, right? Like what would be the first thing that you would describe Wally as, like, to somebody who's
Short,
looking for him in a crowd?
right.
So he's short. He's a really short guy. And while one of the girls had said that he was a shorter type guy, no one said that this guy's really short. Like Richard Allen stands 5'4", maybe 5'5", if he's wearing boots, but he's a very, very small man. And like, so much so that it took me by surprise the first time I laid eyes on him, when he walked into the courtroom the very first time that I saw him. I was like, holy shit, I can't believe how small he is. So but it was enough. It was enough for them to get in, get the arrest warrant. You've got presence at the bridge, and you've got this link, this forensic link between this unspent casing. Now, whether or not that is viable evidence. We could argue for days on whether or not that's viable evidence. To attorneys that have been practicing for a long time, we think it's junk. But the one thing that we can't argue about is that it's very powerful evidence to a jury. Like the distinction as to whether or not it is a piece of evidence that has real value to lawyers is one thing. If it's a piece of evidence that has value to a jury, it's different. And just when you've got experts battling it out on the stand, one saying one thing, one saying the other, ultimately the power of that particular piece of evidence is a scary proposition for defense attorneys. Like we would not love that piece of evidence. Even though we're going to put an expert on to say that that's junk science, that there's no way you can match them. It's one of those pieces of evidence that you are going to have a very difficult time getting a jury to completely disregard.
Right, and
That's just
obviously my biggest concern, and I've always said I've gotta wait till I hear it, are the confessions, you know? Uh, um, I was desperately hoping we were gonna get some details from that when they had the hearing on the motion to suppress. Um, I obviously, I understand and take into account, like, this guy was, losing it by that point. Who knows what or what motivated him to say what or what he did say. We just don't know yet. So, I keep it open in my mind. Like, well, I'm still gonna have to see that. That could potentially change things for me. I'd be shocked because I'll tell you, and it's sort of what I would expect part of the opening to cover. Just the fact that his guy doesn't have any criminal record, any of the you know, I know we've got Dr. Vonda here, but just any of the prototypical background of someone who commits a crime like this, no sort of digital data that is looking at violence or, you know, even children, not violence and not children. No sexual material involving kids, no violent material. I mean, you would almost need something like that. I mean, this is a person that commits a crime like that is either, driven by attraction to children or driven by violence, whatever the case may be. There's going to be a digital footprint of that. There's going to be a history of something. There's going to be someone somewhere saying something was off about this person in this regard. To me, that's always been, very powerful. And, I don't know if something doesn't change and um, I guess we'll get to it when we cover, what they're not allowed to say at trial. But if something changes and they are allowed to bring up um, the Odinist sort of symbolism, whatever it means, whatever it's for, uh, and not having any of that in his background either also, speaks volumes. And hopefully, I mean, to me, there's no way that this was done by one person, and that'll never change. Uh,
yeah, no, and I agree. And uh, no, having no criminal background doesn't necessarily mean anything. I mean, it's certainly an indicator, but that thing that you were speaking of, that people that somebody's inclined to do this, they build up to it. Like you don't go from zero to a double homicide of this brutality without it running through your mind,
right.
probably for years prior to it.
In your
And
search
ultimately,
history, in your
just everything. Like
yeah.
there's going to be there's going to have to be, like you said, a digital footprint of some way that that person has satiated that desire that they have, whatever that dark, sick fantasy is, that there's ways that they do it. And it's typically with the advent of the internet and access to damn near any kind of sick shit that you want to get into. You're going to find that digital footprint, and you're also going to have occurrences of people that have come into contact with that person. We are going to have them have people coming forward saying that they were off, the things that they did or said were strange in retrospect. That's where you get all the retrospect, like, oh, I didn't really think much of it when he said or did something weird at that
Right.
time. But now that this arrest has taken place and I can put it into a different context, now it makes sense to me. And just with this guy, there's been none of that. None of it.
I just want to interrupt to say hi to Sleuthy. We did use your post about with all the different sketches on it. So everyone, that's Sleuthy there. Thank
Hey,
you.
what's up, Sleuthy? Yeah. Yeah, no. So yeah, and with Andrea,
Yeah, we've done something with Andrea.
yeah,
We love her.
we know and love Andrea, and I'm sure that we'll be collaborating with Andrea if she's in fact coming. She was telling me she wanted to come, um, which kind of leads me into wanting to go through this thing that dropped today.
All
So, and
right.
it's the decorum thing. Let's take a peek at it. It's basically the breakdown from Gull on how this thing's going to go. So, this Gull dropped this today. We had a decorum order out. This courthouse management decorum order is a little more. It's got some more specificity, and I think that it'll be pretty interesting to go through it. So, all right, courthouse management decorum order. This case has generated. She always uses the same language. Has generated substantial public interest and media attention. In light of this, interest, the court has set forth rules of conduct and guidelines designed to govern the expectations of the people involved in the trial and those observing the trial, so the decorum of an open court will be maintained throughout the proceedings. The purpose of this order is to secure the defendant's constitutional rights to a fair and impartial jury while permitting the public and the press to exercise their First Amendment rights. In addition, the order protects the identity of the jurors. Pursuant to the court's inherent authority to assure the proper administration of justice, it is therefore ordered that the following rules are in effect. The court may rescind or modify the order at any time. Any person or organization who violates this order will be subject to the discipline of the court, including contempt and permanent exclusion from the courtroom. And then this is where it gets interesting. So we've got the daily schedule, which answers a lot. Okay, so the schedules are tentative and can be modified daily. And as we know, I mean, Gull was not afraid to go late. Now, granted, we did not have a jury impaneled
They
for the.
usually take the jurors'
Yes,
time,
right.
especially
Like,
in a long trial like this, but she's rogue.
yeah. So she had gone to 8:30, almost 9 o'clock on the third day of the hearing. So I mean, she's not afraid to do it. So this is the way that she's got it set up at this point. So the judge invites media representatives to meet with her and counsel of record on October 17th of 2024 at 3 p.m. in the Carroll County Circuit Court at the Carroll County Courthouse to discuss this order. At the conclusion of the meeting, video and or still photographs of the interior of the courtroom may be obtained for media use as B-roll or stock photographs. Jury selection is scheduled to begin October 14th of 2024 and last through October 16th, 2024 in Allen Superior Court. And if you guys don't know, or if you're new to the case, back early on, there had been a motion for a change of venue. What she did is she granted a change of veneer, which essentially means that they will be going to Allen County, which is where she sits. She's the chief judge of the court out there, and they will be selecting a jury of citizens of Allen County, her county, and they will then import that jury from Allen County, put them up somewhere in Carroll County, probably West Lafayette hotel. That's like the kind of the biggest town that's close to Delphi. They could probably put that many jurors up, and she'll have them staying there throughout the course of the trial, which is scheduled to last for a month. Um, so the trial is scheduled to begin on October 17th, 2024 and last through November 15th of 2024.
So they
Oh,
did build in 2 pre-trial days, for jury selection.
yes. Yep.
It's interesting.
Yep. And like she's set an end date on it. Like, and I honestly really believe that she'll stick to it.
I don't know how she can, but
I
we'll
mean,
see.
I just like she'll start warning them like when there's a week left,
Right,
you
but,
know.
I mean, she can't predict everything, so she
She
can
can't predict
try,
it,
she
right?
can, you know, do her best, that's her job, try to keep everything on track, but, you know and that
Yeah,
answers your question, she's planning on 6 p.m. there.
correct. All sessions are scheduled to begin at 9 a.m. and conclude at approximately 6 p.m. It's a long day. There will be a recess for lunch and brief recesses in the morning and the afternoon. And then security during the proceedings shall be provided by the Carroll County Sheriff's Department. All persons entering shall be subject to standard security protocols. Sheriff of Allen County Civil Division officers will provide security in the courtroom and attend to the jury. Upon entering which I like the fact that she's using Allen County sheriffs as opposed to Carroll County sheriffs dealing with the jury for some reason. Upon entering the courthouse, all media representatives shall identify themselves and produce appropriate identification. Now, we know what her feeling on YouTube and podcasts are. She doesn't consider us real media, so I'm anticipating that we're not going to be able to get passes. Additionally, they may not possess any electronic devices, so including audio or video recording device, camera, cell phone, tablet, etc. Media credentials. The court appoints. I don't know if that's supposed to be George James to administer the media credentialing process. Credentials will be issued with the court's discretion. All requests for credentials must be made. It looks like it is I James. I don't know. All requests for credentials must be made to George I. James via email, and then gives his phone number by noon on October 10th of 2024. Any person requesting a media credential must be prepared to present credentials identifying the person as a member of a recognized media organization. Credentials shall be valid for entry to the courtroom during the trial unless they are rescinded by court order. Media should be prepared to display the credentials at any time during the proceedings. Credentials will be assigned to the media organization as opposed to a specific individual in the organization. Credentials may be obtained October 11th, 2024 at 2 p.m. from George I. James. Idjams? It's a strange name. Access to the courtroom. The bailiff will allow the entrance to the courtroom beginning at 8:30. Once a court session begins, distractions will not be allowed. Specifically, the bailiff will only allow entrance and exit during designated breaks in the trial or when a witness is entering and exiting the witness stand. If a person chooses to leave the courtroom during a courtroom session, he or she will not be allowed to re-enter the courtroom until the next break is in the proceedings, which has been her policy all along. I learned the hard way when we were up in Allen County. I left because I had to go to the bathroom in the middle of a witness, and then they wouldn't let me back in until the next witness was seated, or in the interim while they were switching out witnesses. Okay, no person will be admitted unless there is adequate seating. There will be designated seating areas for counsel, parties, families, and credentialed media. The defense will be allocated 10 seats. The prosecution will be allocated 10 seats. The families will be allocated 20 seats. The credentialed media will be allocated 12 seats, 8 for television, 2 for radio, 2 for newspaper, and the general public will be allocated the balance of the seats in the courtroom. Now, the one thing that I don't know, she's got uh, the families will be allowed or allocated 20 seats. Does that include Richard Allen's family? Or is she including Richard Allen's family in with 10 seats of the defense? It seems not right. So I don't know where Richard Allen, like Kathy and his mother, are included in that particular scenario. If the seats are in high demand, media may be limited to one representative from each news organization. Well, that's guaranteed.
I think she probably means like 10 seats to the defense. And then wait, go back up. Where does it say the family part?
It says here, Sleuthy says yes. Yes, all families, 20 seats total.
Oh, the family of the defense and the family of the victims?
She says yes, all families, 20 seat total. So I'm guessing yes.
I mean, I'm surprised it's not in the I'm surprised it's not
This is a very, very small
courtroom.
courtroom.
No, I'm thinking I was gonna go back and say maybe it was 10 to the defense, meaning that's where his family would be. I just don't understand where the prosecution would, like, because it's next to the prosecution, it seems it's like the defense team, like the lawyers get 10 and the prosecution gets
Right.
10.
Well, it's got to be that way. It can't be.
Right.
If the prosecution's getting 10, then the defense should get 10 as well, not including Richard Allen's people. So 40 total seats used up by that. Yeah. No, it's like, and then you've got 12 for the media, real credentialed media, actual media. What did she say? Recognized media. I guess she hasn't gotten the memo that no one listens to like TV shit anymore. They're all like people are just getting their news from Twitter and YouTube. Like they just don't watch news like they used to. Okay, so during jury selection, there will be a reduced number of seats available to allow seating for all prospective jurors. The court has previously issued a separate order addressing jury selection in Allen Superior Court. All reserve seats will be available on a first come, first served basis. Groups will be directed to their respective seating areas. Unoccupied seats in the courtroom may be given to the general public if the court determines it appropriate in the court's discretion. So if there's any dispute among media, example, whether one organization network is taking up too many seats, whether a specific individual constitutes media, hello, whether a member of the press has correctly identified their network affiliation, will be decided by media organizations collectively. If the dispute cannot be resolved by the media and it results in seating issues, the court may employ a blind draw seating arrangement where all present members of the media place their name in a draw and the court seats press according to the drawn names and the number of media seats available. So as to the jury, completed questionnaires will be treated as confidential documents pursuant to provision of Indiana Jury Rule 10. Personal information relating to a juror or prospective juror and not disclosed in open court will be kept confidential, other than for use of parties and counsel. No party, counsel, or staff, court staff members shall publish or otherwise disclose in any way the name, address, or likeness of any juror or prospective juror in the manner that it discloses the identity of that person, except for information which is disclosed in open court. Potential and impaneled jurors will be identified only by their juror number. During the trial, the media is directed that no photograph or record of the jurors is allowed, including the juror entrance exit from the courthouse. If jurors are sequestered, this prohibition shall also include travel, dining, and lodging locations for the jury, as well as parking and transportation vehicles when the jurors are present. The media shall make no attempt to contact or question prospective or impaneled jurors until the court has discharged the juror. Each excused juror will be provided file stamp dismissed / excused paperwork, clearly indicating that he or she is no longer a juror. Like, I'm down with all this. Like in this case, I think the anonymity of the jurors is absolutely required. There's just too many nutballs on this case, like that are just unhinged. So I'm all about keeping the jurors protected for sure. To ensure prospective and impaneled jurors do not overhear media interviews, press interview locations will be restricted. At the end of the trial, the court will ask jurors if they are interested in speaking with the press. The court will facilitate a location inside the courthouse where press will be permitted to interview jurors, if any, who wish to comment. No still or video photography or audio recording shall be permitted in the Carroll Circuit courtroom or the courthouse. So any violation shall result in the item being confiscated and erased, and violators and their affiliated organizations are subject to being excluded from the courtroom for the remainder of the trial. Any interception, transmission, reproduction, rebroadcast, or dissemination of the audio signal created by the court's audio system is prohibited pursuant to the rules of the Indiana Supreme Court. Any voice recognition software used to capture and transcribe courtroom procedures is also prohibited. Still and video photography and audio recordings are permitted only outside the courthouse. All recording equipment is permitted in this area. Interviews. Media interviews outside of the courthouse building generally are not regulated by this order and are instead subject to the administration of the law under the jurisdiction of the sheriff, Carroll County, and the Delphi Police Department. The court must also guard against prospective and impaneled jurors overhearing media broadcasts and interviews. To limit potential exposure to jurors, the court will impose some restrictions as authorized by the Indiana Code of Judicial Conduct, Canon 3B13. No interviews or broadcast activities shall take place in the courtroom or adjacent area. Instead, media must conduct interviews outside of the courthouse. All trial counsel are directed to comply and inform their clients, staff, and witnesses of the terms of this order regarding interviews. Electronic devices such as laptops, iPads, cell phones, etc., shall not be permitted in the Allen County or Carroll County courthouse. Members of the press and public shall not use laptop computers, iPads, tablets, Kindles, cellular telephones, pagers, personal digital assistants, cameras, electronic watches, and or electronic eyeglasses. Ooh, she's hip to those. Parking, no reserved parking. Street side parking is regulated by the city of Delphi. Media organizations are welcome to make contact with ISP, Public Information Officer, Chief Nate Lamar of the Delphi Police Department, Major Tobe Lazenby, or Deputy Mitchell Cantron of the Carroll County Sheriff's Department to discuss accommodations for media satellite trucks or large press vehicles. So media contact pursuant to the Indiana Code of Judicial Conduct, the judge and other members of the staff of Allen Superior Court or Carroll County Circuit Court are unable to respond to requests for comments or interviews at any time. So all concerns and questions from media representatives should be directed to the court. All right, so there you go. So that's it. Pretty straightforward. Yeah, so I think when I counted, I think there were 39 seats open. Okay, and that included, and this is in Carroll County, they had the left side of the courtroom, if you're facing the bench, is where the family of Libby and Abby are typically seated. They usually take up 4 to 5 rows, typically. Usually they have the front row behind Allen empty, and then they had Kathy and Rick's mom sitting behind Rick in a otherwise empty second row, and then the general public is behind there. They typically had one table set up back there, with a few chairs. Now, like for the hearing, she had some other chairs set up back there. I don't know if she's going to do that. So I know a lot of people like Andrea and others, and I heard Lawyer Lee was thinking about coming in. I mean, I'm gonna tell Andrea this is small ass courtrooms. It's a calculated risk of her getting in. I mean, like the concept of us all having to get in line at the crack of dawn every day to get into this thing is horrible. Like I'm ruining it already. I'm already ruining it. Like the concept that I'm going to have to get up at 4:30 to get in line to get in there and then sit in there from 9 until 6 trying to take notes when I really just want to be observing the trial so I can see all the things that I can I need a note taker so that I can observe what's going on in the courtroom as opposed to not being able to look and see what jurors are doing in response to certain things that are said on the stand. I want to observe. I want to observe what the lawyers are doing. That's where I can bring the gold. That's where I can bring like what my thought is on what's going on in this case, more than just sitting there looking at a pad trying to write down every word that's said. That's not my game. It's not my game. It's I was miserable during those 3 days of hearings. I didn't see anything. I was sitting there looking at my pad, like my hand was cramped up, like I had like a claw, man. It was insane. My hand hurt. Like, the last time that my hand hurt like that, babe, was the
Law
bar
school?
exam.
Bar exam, that's what I
The
meant.
bar exam, taking the essays. Like, that was 6 straight hours of or whatever it was, 8 hours of writing. High pressure writing at that. All right, so let me pull this down. So, yeah, I think it's going to be, seats are gonna be at a premium. I mean, I'm gonna give it a shot to try to get a media credential. I mean, if she
I was
hears
gonna
that.
say you should go and, at least hear what she says and what she decides and let her say that somehow, uh, online
Yeah, I love this idea.
journalists don't
I love
count.
this. Dude, I'm already out of pocket huge money on this. Like, honestly,
Line
to
standers.
pay to stay, like, I'm gonna have to rent a room, because it's like I would stay at Hector's,
He's too
but
far.
it's really not too far if I don't have to.
What you gotta do is get to an Airbnb, not a hotel. That's silly.
Yeah. Yeah, I've had offers of
The royal we
Airbnbs.
will stand in line for $1,000 a day. Now Bob will get his ass up. He'll get in line, save the money for all sorts of other things.
Yeah, $1,000 a day.
Hey, I'll stand in line for the $1,000 a day. Wait, not from you though. That don't
Yeah,
make
I think I think that you're ultimately going to be, like, we're gonna have to alternate. Like, I
damn
want
it.
you in there.
Andrea's already got an Airbnb, so gotta see if she's got more than one room. That makes the most sense to team up with another lawyer, especially if it ends up that only one of you guys can get in.
Okay. Yeah, I'm gonna have to figure that out. Like, I've had a couple people offer Airbnbs, like rooms. I'm gonna have to just try to figure it out. Like I wouldn't if I can figure a way in to where I don't have to wait in line.
Bob's a master line stander inner. Come on.
I can stand in
You
a
can stand in a
line.
line.
I can stand in a
Gotten
line.
into many a concerts where we've had to, got this line thing down.
Um, yeah, yeah. I I don't know. It's like the thought of it is horrifying. It's like no, oh man, it is. Like the concept of standing in line all day, and it's a long day. And those seats, those benches, and their
I'm
seats are
absolutely
so
certain
uncomfortable.
that Travis is accurate and can find, like, super inexpensive line stander inners.
Yeah, he's probably right. Um,
No, no live tweeting during trial, right?
nah, no live tweeting. We can't even bring our phones in. Like, she used to let us bring our phones, and she's not allowing any phone, nothing, no electronics are gonna be allowed in that building. So it's gonna be radio silent until lunch, and then that's it. And then after, when when we go live, that's gonna be it.
I
So,
was trying to get Bob to not do live and to do more structured format, um, but since we won't have any audio, there's not really much of a reason to do it that way, like the way we did the Vallow trial. If anybody has listened to the Vallow coverage that we did on the podcast, I was thinking of doing it more that way, where we spend, like, a shit ton of time, but there was audio, so it was different.
Yeah. Um, yeah, I'm like, I'm gonna have to figure it out.
I'm
It
thinking
really
we do some, like, pool and try to get, daily transcripts.
no
Oh,
way.
thanks, Spitfire.
I don't think, I don't think they're gonna be I don't think they're gonna be putting those transcripts like, they're not doing it daily.
Well, if you pay for it daily, they're doing it daily.
You think if the general public's paying for it daily?
I feel like if someone's paying the court reporter to produce it daily, they're gonna produce it daily.
Yeah, well, for as many times as I've been on court TV free, they owe me a pass as far as I'm concerned.
Well,
That's just how I feel
you
about it.
gotta start pulling in your shit, man.
Now they'll have like court TV will have Barb. Barb will be the court TV correspondent for them for sure. Like there's no question about
Yeah,
it.
they're not gonna be able to get, like, a bunch of people in with that kinda numbers.
No, like they said, each media company is going to get like if there's going to be a lot of media companies trying to get in there, they're just going to limit it to one. So like I'm imagining Barb, I mean she's a senior writer for them. Like she'll have to be the one. I don't know
Alright,
who
so are you
wants
gonna get
like
into what to any actual trial stuff? What do you
yeah,
wanna
well,
discuss
so
here?
like I want to go through a couple things that were filed that I want to talk about a little bit. They're not lengthy. So there's a couple. One, I don't know if you saw, and I don't know if we did a live about it, but the defense had filed a motion that they wanted to do a mini opening during voir dire. Did you see that? And I think she actually granted it, which is
Really?
interesting. Yeah, yeah. All right, so let me pull this up. This one's interesting. So this is a motion for the jury to view the scene, field trip. So Richard Allen, by counsel, asked the court to order that the impaneled jury be transported to the Freedom Bridge, the Monon High Bridge, and to the site where the bodies of the victims were located, as well as the site of the old CPS building where the prosecution claims Richard Allen's vehicle was parked between 1:30 p.m. and 4 p.m. on Friday, 13th of 2017. The view would be requested as it would greatly aid a jury's understanding of the evidence at the trial, including observing and feeling the unique topography of the land, something that cannot be understood from photographs and video. I 100% agree. This is one of those situations where I am absolutely in agreement that the jury should go out there. It's such an unusual situation. Like down the hill doesn't mean anything until you go out to that bridge and like walk it. Like it's a whole thing, and it doesn't exist like it did then. You know, it's like they've refurbished it. Because back in the day, 2017, man, the bridge was scary to walk across. You had beams, railroad ties that were rotting. It was a scary thing. Um, okay, so let's see. All right, so specifically, the request is for the jurors to walk the trail from the Freedom Bridge to the Monon High Bridge, to then view the opposite end of the bridge where the victims were allegedly abducted. Finally, to view the area where the victims were found, and then the location where the prosecution claims Richard Allen parked his car from 1:30 to 4 p.m. on Friday the 13th or February 13th, 2017. These locations are less than 2 miles from the courthouse. Juror transport and viewing could easily be completed in under 90 minutes. Allen and his counsel, Baldwin and Rosie, and Jay request to be present along with the prosecution and observe the viewing under whatever direction and guidelines the court may order under Indiana Code Section 35372-5. If, because of any security concerns, the court does not wish to allow Allen to be transported to the scene, he waives any such right and asks that the court order this jury view occur without him. So interesting. Like, I'd almost want, if I'm the prosecution, I'd want him out there to see if has any kind of visceral response, right?
Yeah.
If I'm the prosecution, I'm saying I definitely want him out there. But I could see that being a real security problem, though. Um, so, all right. So she has taken that. So the state objected. Okay. Now comes the state of Indiana by prosecuting attorney Nicholas McClellan and respectfully objects to the court ordering the jury to be transported to the Freedom Bridge, the Mona High Bridge, to the site where the bodies of the victims were located, and to the site of the old CPS building to view those areas. The state would, I think it's supposed to be, ask the court to consider the following: that the defense filed a motion to have the jury view the scene on September 23rd, 2024. That the state objects to the jury going out to view those areas requested by the defense for the following reason: the terrain where the bodies were found is very difficult to traverse, and would be dangerous for the jury to get to. That traveling to where the bodies were found and to the opposite end of the Monon High Bridge would involve encroaching on two private landowners' property. That it would require a substantial amount of time and resources to take the jury to those areas while ensuring that they are sequestered from the public and outside influences. That the areas of where the bodies were found, along with the site of the old CPS building, are substantially different from the times the crimes occurred. The state intends to introduce into evidence demonstrative exhibits, maps of the various areas, and drone footage of the various areas to show the jurors the various places outlined in the defense's request. That any benefits of the jury visiting these areas is outweighed by the dangers such a trip presents to the jury and to the fairness of the trial. That the state does not believe it is proper to have the jury view the scene or the other various areas. So what do you think?
I started paying attention to something else. So,
What were you paying attention to?
uh,
Is it
nothing
anything?
but
It's nothing interesting?
no, sorry.
Hmm.
So you're talking about the state's objection to the defendant's motion for the jury to view the scene. And so they're objecting because
I just
why?
read it. What were you reading? Like, you weren't
Sorry.
paying any attention? What were you looking at, though? I'm curious.
Uh, like something that this footnote index that was created before we left that I didn't realize that, so I got a little sidetracked, sorry.
Wait, footnote index of what?
Nothing to do with Delphi. Forgive me.
Really?
Yeah, I didn't realize you were gonna ask me a question. I thought I was gonna be quick.
Oh,
Well, look, I'm gonna say this. I think that with that scene that they should be able to go out, and I you know, I don't know. It's like what the state's trying to hide the ball. I mean, why don't they want the people to see the scene? The only reason they wouldn't is because they don't want people thinking, "Now, this seems like not one person might have done this," or "This seems like it's way more involved than what, you know, than what."
sorry, I wasn't listening to you. What were you saying? Are you serious? Like, what were
Okay.
you tell me you weren't looking at that thing? Like,
All
you were
right.
looking at that thing when we're on a live?
It was like for a second, and I missed that. I'm
Like, what
sorry.
possessed you to do that? Like, we're in the middle of a live. We
I
haven't been
know.
on live forever, and
I
you're
know. Everyone still loves me.
I mean, that's for sure. I mean, I still
I'm
love you.
sorry,
It's
I'm
not
not
it's
gonna do
not
it
a
again.
matter of loving you, it's a matter of,
I
being
know, I get it.
slightly perturbed. Okay, state's motion here's how I'm gonna have this happen, like, you're gonna read this one, then I know
Okay,
that you're paying attention.
got it.
Okay.
Uh, Now comes the state of Indiana by the prosecution, Nicholas M. McClelland, right? McClelland, for the 74th Judicial Circuit and respectfully request the court enter an order prohibiting the testimony by Mr. William Tobin, a listed defense witness regarding firearm examination in general or the firearm examination specifically in this case until a hearing may be held outside the presence of the jury to determine the relevance of Mr. Tobin's testimony in support of its motion. The state would show the court the following: that William A. Tobin, as listed defense witness, was deposed by the state on September 20th, 2024. Wow, they're still doing depositions.
Oh,
Uh,
yeah. Kidding me?
Mr. Tobin has testified that he is a forensic, what the hell is that? Metallurgist? I can't see it. Metallurgist. What the hell's a metallurgist? And material scientist. He has a Bachelor of Science degree in
It's like somebody who
metallurgy.
studies metals. What do you mean?
I've
Like,
never heard of this expert.
except for one of our favorite scenes in Oh Brother. Any of you boys middies or otherwise trained in the metallurgical
Metallurgy.
arts?
Yes, that is true.
Alright, there you go.
All right, a Master of Metal, and a Master of Arts degree in Special Studies, which he testified was primarily the study of law. You can scroll up, babe. In his
Okay.
deposition, Mr. Tobin testified that when he has been recognized as an expert in court, it has always been as a forensic metallurgist. Am I saying that wrong? Metallurgist or material scientist. Mr. Tobin stated that he has not examined the evidence in this case, though he has testified he has reviewed some of the reports and notes of the state's firearm examiner, Miss Melissa Oberg. Mr. Tobin testified that though he has not reviewed all of Miss Oberg's material, he has what he typically needs to be able to opine on the methodology that's used. Tobin went on to explain that the state's firearm expert witnesses' conclusions are based on flawed methodology. According to Mr. Tobin, this flawed methodology is the Association of Firearm and Tool Mark Examiners theory of identification, and this theory is what almost all firearm examiners follow, whether or not they are members of AFTE. That Miss Oberg, at the time of her examination, was a forensic examiner with the Indiana State Police, and she, along with other Indiana State Police firearm examiners, follow and apply the AFTE theory of identification. Mr. Tobin is not an expert in the field of firearm examination, unlike another listed defense witness, Dr. Eric Warren. Dr. Warren, like the state's expert witness, Miss Oberg, is not only a member of AFTE, but holds and has held leadership positions within AFTE. Mr. Tobin's expected testimony will be that all firearm examiners, including Ms. Oberg and Dr. Warren, followed a flawed methodology and their opinions are not scientifically reliable. However, the state believes that Mr. Tobin, who is not an expert in the field of firearm examinations, lacks the qualification to testify regarding the firearm examination in this case, and that his knowledge is not such that it would help the trier of fact to understand the evidence or determine a fact at issue in this case. Further, the state believes that Mr. Tobin's testimony would lack relevance under Rule 401, since he is not an expert in the field of firearm examination. Finally, the probative value of Mr. Tobin's testimony would be substantially outweighed by the danger of confusing the issues and misleading the jury. The state believes that the question of whether or not Mr. Tobin should be permitted to testify in this case is very similar to a recent case out of Marion County, State v. Indiana v. Caden Smith. In the Smith case, Judge Harrison ruled that Mr. Tobin would not be permitted to testify. In her order dated January 29, 2024, said the witness, Mr. Tobin, was being called by the defense to testify only as to the shortcomings of firearms examination in general. This witness has not tested or reviewed any of the evidence in this cause. The defendant will have the opportunity to cross-examine the state's witness to present his defense as the shortcomings of the firearm examination. The court now grants the state's motion in limine. All right. Wherefore, the state of Indiana, by the prosecuting attorney, Nicholas McLeland, respectfully requests this court grant the following relief: order the defendant, through his counsel and witness, to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to any of the above matters without first obtaining permission of the court outside the presence and hearing of the jury. B, to further order said persons to make reference to the fact that this motion to make no reference to the fact that this motion has been filed and granted. Oh, yeah, he's already predicting the granting, and all other relief just and proper in the premises.
What do you think of that?
Well, I don't know. I mean, I think that it's like the courts decided that this, expertise or this testing is scientifically reliable. So the question of whether someone can put on evidence demonstrating that it's scientifically flawed, um, it does present an interesting question in the law, and I think that there should be a hearing to determine whether it is, um, whether there's some validity there but I mean, like this court's ruling in this other case, it it's you don't know that you're gonna need an expert. If you're gonna ask these questions, right? Your expert, this Mr. Tobin, he
Yeah.
tells you, you know, ask X, Y, and Z. Like, well, when you do this, isn't it possible that you could get this? Or, like I can't think of any like example questions to give right now, but something to that effect where you're able to draw out on cross-examination the shortcomings. You're able to point it out. You're able to use other materials. Have you reviewed this and have you reviewed that? And then if there's something that's still out there, right, that the expert denied or said, no, that's not an issue at all, then maybe there's a reason to get it in. But I mean, they've got this one case. You've gotta see if this guy has been allowed to testify in other cases. Go back to where
Well,
is that
it says that he was deposed and that he's testified that he's a forensic metallurgist and material scientist, and that he has been recognized as an expert in court, but it's always been as a forensic metallurgist or a material scientist, not. So, I mean, my question is, does the defense have a straight up, tool marking expert? Like, is
well,
this guy like in
they
in
did mention
addition
that
to?
they did mention that he has uh, there is someone on their list that is the same a firearms expert, just like the state's firearms expert, and that this expert, Tobin, is basically saying that all the experts that are using this are doing it wrong.
Well, I think that it is interesting. I mean, it warrants what
I'm
we
gonna
would
do
call
some
it.
more looking into it, and when we do our primer, we're gonna come at you with, like, some shit.
Yeah, well, I think that it warrants a Daubert, but I mean, they don't really follow Daubert per se or Fry in Indiana. It's kind of like a
Right, that's why I'm saying I think that
for
it's
them it
kinda like
goes to weight. Like, so for him to be coming with this shit, her answer should be for the same reason they're allowing the
scroll down to that case where they excluded him.
wait, was it a case that
There it is. Yeah, there it is. State of Indiana
they
versus
didn't exclude him.
they excluded his expert opinion in this regard.
Oh, I guess I should have paid attention when you were reading.
Aha! Really?
Uh-huh, yeah.
Ah, touche. Oh, I forgive you for having attacked me the way you did, I mean, not for not listening.
Yeah, I attacked you.
Attacked me.
All
I'm
right,
sure
let's
some
see.
people are gonna really feel that way anyway.
Yeah, that I was
See how
attacking you for
Bob just came
reading
at her?
something completely unlielated to
I
Delphi
know, I'm
in the
sorry,
middle
I'm
of a live.
sorry. You're right, you're right.
Uh, it's not cool.
Um,
All right,
Marion
okay, so
County.
let's
What
see.
county are they in?
Travis says Dr. Warren and Tobin have been the ones who have gotten uh, the Fathom evidence excluded in 2 states or severely limited in 9 states and federal courts after Dauber hearings, right? I mean, that's
That's
the
something.
problem here, Travis, is like they don't really do Dauber hearings, like,
Right,
'cause
but all the principles of Daubert should be applicable, right?
but
I mean,
they're
all
like
the underlying
it goes to weight in Indiana.
it goes to
Like,
weight everywhere.
no, but like they don't look at it as an admissibility issue. Like they're just they don't give a shit if like
Well, that's
no
even more of
court.
a reason why they should be allowed to put on counter evidence showing.
Exactly. That's what I'm
Right.
saying because it'll go to the weight. They can give this guy whatever weight they choose, but they can't exclude him from him coming in and saying that the entire system that they use is bullshit. And these are the reasons why. You know what I'm saying? It's like, I mean, they're going to have their own tool marking
Well,
expert.
they
Like,
they have an expert, a firearms expert, same as the states that they mention there, and that this expert, Mr. Tobin, would say that both the methodology followed by the defense witness and by the prosecution witness are bunk
right.
because they follow the same methodology.
Right. I think it's fair. I
I
think
think
it's
it's fair
fair.
too. I mean, it's literally, b like, um is being pointed out. I got my thing blown up because I was trying to read that. Like Travis is mentioning, um, hmm. So Warren and Tobin have together done this? They've okay.
You mean
So
their expert?
well, yeah, because Dr. Warren is their expert, who's a
Right.
tool marking person, and Tobin is the one that they're trying to exclude, and Tavis is saying that they have, like,
Duked
together
it out
done
before?
this. No, it sounds like they work in tandem, you know? You you use both. Like, "Alright, I don't find I think this methodology is flawed. It's the one that's being followed. It's the one the state followed, and when I follow it, this is what I get," is what I'm assuming. I don't know, but, um, uh it's you know, it's definitely interesting, and I think, like you're saying, because here they don't even have, like a Daubert hearing or something to decide whether something that the courts used to determine. I mean, there's clearly a basis in the law to say, all right, this that you once believed to be the end all be all, you know, is not reliable anymore. Like they did with um lie detector tests, used to be allowed, and then they realize the flaws in it and they don't allow it you know
Yeah.
I think that's more of a reason why there should be allowed to be an expert, but I'm saying is on the flip side of it, it might be stuff that they can get out in cross-examination, and it might not be. So it could be something where the judge says, "Well, here's what we're gonna do. We're gonna put on the state's gonna put on its case, you're gonna cross-examine, then we're gonna have this little hearing to determine whether or not your expert." That's what the defense should say as well, that they want,
Oh, for
because
sure. I mean, she has to give them the opportunity to be able to rebut it scientifically beyond just cross-examination, I would think. You know what I mean? Because,
if
like,
I
look,
was the
you're
defense, I'd
not
be
going to get somebody who uses that particular, that particular system,
"Oh, you think
in
these
ter
people all wanna be out of a job? Come
right,
on."
right. Well, you're not gonna get a state expert to say, "Yeah, you're right. What we use is bullshit." Like,
Right,
that's not happening. Like, I don't care what they ask on cross. They could have this guy, give him a million questions to ask on cross. You're never getting that expert to step back and say, "Okay, yeah, you got me." So that's why you have to be able to put your expert on to say why it's bullshit. 'Cause they'll be able to get the questions out, but whether or not it's gonna resonate with the jurors is what matters.
right.
Like Baldwin or Rosie, and I'm sure it's gonna be Rosie because I think he's gonna handle the gun stuff and the confession stuff. And it's going to be very difficult for him to be able to impart what he needs to impart to a jury through cross-examination questions wherein that witness is not going to ever agree with any negative critiques of what that witness uses in order to make scientific evaluation. So, she's got to allow them to put on a defense at some point. She's got to allow them
I
to put
mean,
something on.
we've seen that she really, you know, uh, I don't know, she's got no bones about just cutting a defense off at the knees and then not even certifying it to be decided on appeal, you know?
Yeah, no doubt, no doubt. Yeah, so I like, I don't know. Um, all right, so there was one other thing I wanted to pull up, and it's this. But yeah, when we do our trial primer, we'll get into the weeds on some of this stuff. Okay.
Yes.
Like including that. And maybe we'll like Travis, maybe we should have Travis on. I think it's long overdue that we have Travis on.
Yeah,
Um,
I mean, Travis has been super helpful throughout all of this, and he's very knowledgeable attorney as well. So, um, maybe we uh, or maybe we do something more broken down after the initial primer, because I feel like the primer alone is going to be a lot, and then I think we do like a micro, what's it called? Like when you a macro level, you know, primer where we have Travis on.
yeah, yeah.
We do
Um, and Travis is right. I
our
mean,
macro, then our micro.
the case is already like the court's already found that they're going to be able to say that it's a match.
That's did I miss that hearing? That's what I never understood. Where was that
It
hearing
it
where the
wasn't a
defense called
hearing.
an expert?
She ruled without hearing
Th
once again.
that is absurd. That right there, that is one of the things that you cannot do. You cannot rule on something like that without allowing the other side to say why they shouldn't be like we filed a motion in a case where they were using the mitochondrial DNA, and the law says you cannot put in a DNA without a statistical counterpart. So what if we would have just filed, and I don't know how it got heard. Was it the state's motion to allow them to say that, or the defense's motion to bar?
I
But
think
in
it
any
was
event,
I think it was the defense's motion to bar it
right,
because they were
she's got to give them the opportunity to present an expert, analysis as to why. It's outrageous. But, well, the example I was giving, could you imagine if if the judge just ruled on paper without,
no.
without a hearing? I mean,
No, I can't. Like,
when
look,
she
I know
can do it, I'm the first to say it. Like, "Hey, look, on a, uh, motion attacking the warrant, you've gotta make your, headway on paper first, and if she's gonna say, 'None of this matters to me, it wouldn't change my mind anywhere,' I mean, it's I just don't know how they can how she can allow them to use the words match, without having any sort of hearing. It's that one is one that really sticks in my craw.
yeah, it's on I mean, like, it's what I've been bitching about for a year plus, it's like that she's granted I mean, even the 3 days of hearings was really at the behest of McClelland. Like, the hearing about whether or not they were going to be able to bring in a defense relating to Odinism or third party culprits was at the behest of McClelland's motion. So it's like she grants hearings for those, but ultimately at the end of the day, how this will be viewed by the appellate court if he's convicted, I don't think that's going to go very well, aside from the fact that there's 61 confessions of some sort or another. It's like if those confessions have the kind of information that only the killer would know. And the defense's argument is, well, he had access to the information because he had counsel who had the discovery, who was discussing it with him, who had dropped off, who had gone through the discovery with it. You know what I mean? Like like that's a tough argument with that kind of number and I'm sure a majority of them are going to be like I killed the girl type things, like where he's just saying that, like not getting into details,
Right,
you
and
know. And
unfortunately, when you have a cop saying, "I think the details he provided are specific to the offense." Bob and I have, throughout our career, read so many police reports summarizing what somebody said and, restating what was said, and then when you listen to the actual interview, there's so much mental gymnastics in what the police report is saying. Like, it could be read in numerous different ways that I just can't at face value accept the cop testifying like, "Well, yeah, I think that part of the information in the confession was something that only the killer would have known," without any details about what specifically was in the confession that only the killer knew. And I don't know why I just used that, um, example, like, why I just went there. What were we talking about? There was a reason that I was kinda giving that as an example. Um,
What do you mean? What we were just talking about?
no, I know we were just talking about, like, excluding the gun stuff, but I don't know what made me go to make that point. I just lost my own there was a reason why, like, I wanted to point that out about cops not being forthcoming uh, in their analysis that was gonna tie back to this, and I lost it, sorry. I don't know.
Yeah, I don't know either. As much as I'd love to get in your brain, it's super hard to do. Um, yeah, I think that, yeah, ultimately this thing is gonna have to like, she's gonna have to allow it in and just allow it to go to wait or like you said, you know, I mean, it's gonna have to be a thing where, you know, she'll take it as it comes and say, "Okay, you know, I'm gonna let them do what they can on cross. If I feel that they were able to get enough in through cross, then I'll bar them from testifying." But you
Right,
know,
or
it's like when why it reminds me of in the Garcia trial where Randall ruled that our DNA expert, Carl Reich, who's brilliant, was not going to be able to say that the DNA found on Butra's door handle on the attempted burglary case was not Anthony Garcia's DNA unequivocally, you know, because they had brought in or
Trulio.
tried to bring in True Allele. And at that point, True Allele was like, I'm not giving my algorithm over to anybody. It's the entire value of my company is wrapped up in my algorithm. If I just put it out there, my company becomes valueless. And so in that case, in our
And
case,
that was it was literal without having to get into it, like, junk results, like, the results didn't even make any sense based on their own way of, like, setting it out, that it was, like,
right, it was garbage
50-50.
in, garbage
It was,
out.
like, 50-50% chance that this 50-50 could be right, and if it is, then it's 1,700,000,000 and a trillion, but it just it was not like he had that was absurd. So what Bob's saying is that the judge basically in that case strong-armed him to say, if your expert's gonna get on and say that that DNA is not the defendant's, I'm letting them put on this complete and total junk science, that says it's 1,000,000,000% him when otherwise the state was left it's like 1 in 12
And when
chance.
I challenged the judge on, I'm like, well, how are you going to do that? Because the problem is that we couldn't have the Daubert hearing. Like we couldn't have a Daubert hearing because he wouldn't turn over the algorithm to let Reich look at it to see if it was bullshit or not. So we called it like it was like the nuclear option. Like if we felt the trial was going poorly, we were like, do we have to do the nuclear option where we put Carl Reich on and Reich writes like Carl Reich's brilliance is that his ability to be able to dumb down DNA for idiots like myself who don't understand DNA at all to understand it. Like that was what made him such a brilliant scientist and still does. Like I think he's the best DNA guy out there in terms of trial work because he really has a way of creating
Right, so
a DNA
circling
for
that back
dummies.
to this is Bob's whole point is that she's gotta allow this she should, but obviously, she's a whole different beast, sort of like what we dealt with, let this evidence, this witness on to challenge the, like the testings and all of that, but I do think that if the argument is made even more like over and above what we're saying about was there enough that came out in cross, that only after this expert testifies, the state's expert, and even with cross-examination, will the issues, like, that still remain and how this expert, Mr. Tobin, could be help the jury to understand, I don't think it could get properly determined until that point. Like, I would be pushing for, "You've gotta let this in, you've gotta let this in, you shouldn't leave it out, blah, blah, blah." Alternatively, we should have a hearing after their expert witness testifies and is cross-examined to determine, you know, if this evidence will assist the defense. I mean, the trier of fact, the jury, to understand anything. Um, right, and I remember that that's what I went to about the statement that only the killer would know, and, like, that was what I was saying as far as cops just say anything, but I was gonna circle that back into something else that I lost, um, you know, I lost what that he was tick things only the right, he was saying things only the killer would know. Um, you know, anyway, I was gonna roll that into something else, but I forgot what that something else was. But yes, for sure, the cops saying that means nothing to me, even more nothing than um, having not heard the statements. And, it's starting to happen now with all these publicized trials where, for years, and those of you who have listened to Bob's content and him and I talk know that we've said how often, like, the defense attorney is also sometimes villainized, and they're quick to believe defense attorneys are making up a story or, you know, full of shit, that now it's coming out so often, like what you saw in the Alec Baldwin trial, and like what we're seeing in the Young Slug trial, where the judges are seeing, like, wait a minute, prosecutors lie? And it's happens a lot, and they're doing all these things wrong, um, but it takes so many occasions of something like that to happen before it sort of becomes accepted, and, there's a shift in the judicial mindset. Um, but
Yeah. Yeah, Dizzy's not in here. She had something awful happen. And I'll let her talk about it, but she's not here for a reason. Good reason. Um,
that's
she's okay, but there's, yeah. I mean, okay. So this motion to compel deponents to answer certified questions. So if you guys don't know, when you're doing a deposition of somebody, and they typically will always have their counsel there, um, almost always,
or the state,
or the
the
state,
opposing party.
depending. Right, the opposing party will typically be there, and certain questions can be asked, and that person's the deponent's attorney can object, and at that point, like a lot of times, most of the times, like Alice and I will allow our witness to answer, or our party to answer.
Right,
Um,
typically, you put the objection on the record, you let them answer, but sometimes it's something that the attorney absolutely, positively does not want to be said, and then they do what's called, "We're gonna certify the question," and then it gets sent to the judge. Should the person deponent, um, have had to answer this question, this is it, and then the judge decides whether they should have to answer it.
yeah, for sure. Um, okay, so this was filed by Alan Baldwin. Respectfully requests the court to compel certain deponents to answer certified questions. So, over the course of time, several deps have resulted in the defense certifying certain questions where the
People are
prosecution.
asking, I think, the date on this, like, are you talking about something old?
What? This is older. This is from September 23rd, but we were gone.
Okay.
We were in London.
Oh, they're
Why?
talking about something else, it looks like, sorry.
What were they talking about?
I don't know. Becky, Patty, Barb, I don't know, what's the date on it? Prove me wrong. I don't know. Go ahead.
Oh, Forrest. Thanks, Forrest. Appreciate that. Okay, so over the course of time, several depositions have resulted in the defense certifying certain questions when the prosecution advised the deponent not to answer certain questions. The defense is requesting the court to order the deponents to answer the certified questions. Certified questions, the defense seeks this court to compel the state's witness to answer are contained in the following paragraphs. On August 10th, 2023, the defense deposed Sherry Holman, and the following question was certified. What did you talk to Sheriff Liggett about to prepare for your deposition? And then on May 3rd of 2024, the defense deposed Jerry Holman, and the following questions were certified. What did it take? Why did it take you guys so long to get a blood spatter expert in April of 2024? Why did it take so long for the investigators to get a blood spatter expert? Did anyone in your unified command or greater law enforcement investigative team ever suggest that you should do that? Retain someone to discuss blood spatter during the investigation. So then on March 22nd, 2024, the defense deposed John Gallipo. And the following question, who is the warden at Wabash? And the following questions were certified. I'm assuming that some of that, talking to the prosecutor, was just talking about pleadings I had filed or Andy filed, things like that. And B, and so what you were asked to do when you got the document, affidavit signed by John Gallipo, did you give any reason why the defense could not go see where Richard Allen was living? And D, do you know why they made that decision for no phone policy in Westville Correctional Facility? So on April 18th of 2024, the defense deposed Joshua Robinson, and the following questions were certified. Joshua Robinson was one of the Odin patch guards. A, generally describe to me what kind of questions these were. Questions for the affidavit prepared by Elise Gallagher. And then B, I'm not asking you about what Miss Gallagher talked to you about. I'm asking you what questions you answered for the affidavit. And then C, what were those questions for the affidavit? On May 3rd, the defense deposed Tony Liggett, and the following question was certified. What was the purpose of that meeting, the Unified Command meeting? And then on September 13th, 2024, defense deposed Steve Mullen. And Mullen refused to answer questions posed in subsections A through D below. Rather than simple yes or no question, Mullen repeatedly made conclusory statements to the defense counsel that Richard Allen was the man that Betsy Blair observed, and was the man that Sarah Carbaugh observed. The deposition has not yet been transcribed, so the defense cannot be certain as to the extent, as to the exact questions formed at the deposition. But the questions certified were to the effect of A and D below, or if answered, would have led to questions similar to A and D below. A, is your timeline and theory of the case fatal to the prosecution's case against Richard Allen if the person Betsy Blair observed on the bridge is not Richard Allen? So it's a good question.
Wait, they wouldn't answer it?
No, he said he wouldn't. He said that
timeline and theory of the case fatal to the prosecution's case if the person I mean, it seems obvious the answer is yes.
right. Well, because he just saying it, the person that Betsy Blair did see is Richard Allen, so I don't have to worry about that. That's what Mullen was saying. So is your timeline and theory of the case fatal to the prosecution's case against Richard Allen if the vehicle Betsy Blair observed at the CPS building was not Richard Allen's vehicle?
Well, I'm sorry,
So-
it was Richard Allen's vehicle, so I don't have to worry about that.
Right. You see, the problem was that's where like the car that looked like a Mercury Comet, like a 67 Mercury Comet or 64, 65 Mercury Comet. That's like like the old muscle car that looks nothing like any of Allen's cars. So if Betsy Blair observed one person and Sarah Carbaugh observed an entirely different person, is the prosecution's timeline and theory of the case as it relates to Richard Allen fatally flawed?
I mean, I can see her taking some issues with the question the way it's worded. Like maybe it needs to, because that's asking for a conclusion. Like, is it fatally flawed, maybe? As opposed to something like, does that mean it could not have been Richard Allen? Like, like more specific as
Right.
opposed to
Yeah, so it's like he's saying rather than answer the simple yes or no question, Mullen repeatedly made conclusory statements to the defense that Richard Allen was the man that Blair observed and the man that Carbaugh observed. The deposition has not yet been transcribed, so the defense cannot be certain as to the exact questions formed at the dep. So he's guessing.
I mean,
Like
I
he,
think the fact that you may just be able to use the fact that he was so evasive during the deposition when you ask him the same question, you know, on the stand.
right? Why wouldn't Mullen just say
Unfortunately,
no?
Bob and I can't really speak to what the judge is gonna how the judge would rule on something like this because it's not something that, we have in Illinois, so it's not something that we're
Yeah, we don't get to depose witnesses in Illinois in
but
criminal
just
cases.
thinking of it, abstractly, I can see some issues with the wording, about, like I said, is it fatally flawed as opposed to a more specific, um, question. But do we know, is this something gonna get set for hearing?
You're asking the wrong dude. Like I mean, I like I don't know if she's gonna set it for hearing. She hasn't said anything for hearing. Eh, I mean, it's like I think she'll probably rule. So the last one is if neither Bessie Blair nor Sarah Carbaugh observed Richard Allen on the 13th of 2017, is the state's timeline and theory of the case as it relates to Richard Allen fatally flawed. So those are the ones that they certified and want the judge to rule on. And then I think the state. So I know that the DOC responded.
To that?
Yeah. So this is that.
Department of
So
Corrections?
yeah, because of Gallipo.
Well, how
Y-
would Gallipo know? Oh, okay, it
Yeah,
wasn't about the
different
fatally flawed
questions
questions. Okay.
because
I was
they had deposed Gallipo and the Odin Patch guy, Josh Robinson, one of the guards.
I'm not allowed to talk about that, so I can't see how she's gonna force him to answer it.
Right.
Except to make the record, they should be allowed to, so maybe she will make them answer it. It's, actually more of a reason to make them answer it because she's not allowing it in, and it might, you know
Right. Well, I don't even think that they were asking about Odin shit. I mean, they were definitely not asking Gallipo anything about Odin stuff. They were asking him um, about getting back to look at Alan's cell and things like that.
attorney-client privilege for the DOC, what's this
So it
argument?
says that because they're talking about correctional Sergeant Robinson was deposed by the defense on April 18th of 2024, and the questions about his affidavit in the Department of Correction was present by counsel at the DEP. So Elise Gallagher holds the title of Deputy General Counsel for the Indiana Department of Correction and is an attorney licensed to practice law in the state of Indiana. So Gallagher provides confidential legal advice to that Department of Correction to the Department of Correction. So they're citing
Well, what
privilege,
I would like to know is, was there anyone else present, like someone for the prosecution? Because that would
destroy
obliterate
privilege.
privilege.
Right. Um, it's hard to know. Like, I mean, during those conversations, like that's what matters if they're present during those conversations. So, privilege applies to all communications between the client and the attorney for the purposes of obtaining professional legal advice or aid regarding the client's rights and liabilities. Okay, so Gallagher was consulted in her professional capacity and provided confidential legal consultation for her client, the Indiana Department of Corrections, by communicating with Mr. Gallipo concerning his affidavit, which pertained to his professional role at the department with the DOC. She was
Yeah, but
also
she
consulted with respect to Robinson and his
yeah,
role.
so that only protects the question was, what did he talk about? Uh, can you can you email that to me so I can look at it? But the question was, I thought, what did he review and what did he talk
Here
about with someone?
they've got it here.
Oh, okay, go ahead.
So the answer to the question identified in paragraph 6B of Mr. Allen's motion is protected by attorney-client privilege. Question: and so what were you asked to do when you got the document? Affidavit signed by John Gallipo. Basis of privilege. Mr. Gallipo's testimony was that he believed the affidavit to have been prepared by the legal team at the Indiana Department of Correction, and that he had an in-person meeting with someone on the legal team. Question calls for a response. It was what Mr. Gallipo was instructed to do by a DOC attorney at that meeting. So then 17, the answer to the question identified in paragraph 6C of Mr. Allen's motion is protected by privilege as well. Question, did they give you any reasons why the defense could not go see where Richard Allen was living? Basis of privilege. Gallipo's testimony was the decision in question was made by the legal team at the Indiana Department of Correction. The question probes the legal justification provided by the legal department. Moreover, in order to compel an answer to the question identified in paragraph 6C of Mr. Allen's motion is unwarranted because, notwithstanding the objection, Mr. Gallipo answered the question. So the answer to the question identified in paragraph 6D of Mr. Allen's motion is protected by privilege as well. Question, do you know why they made that decision for no phone policy at Westville? Oh yeah, and that's where Gallipo was, Westville, not Wabash. The basis of the privilege of Mr. Gallipo's testimony was that he believed that the policy decision to have been made by the DOC legal team. Question calls for Mr. Gallipo to divulge the legal team's rationale. And then application to Robinson. Questions generally described to me what kind of questions these were. Questions for the affidavit prepared by Elise Gallagher. And then I'm not asking you about what Miss Gallagher talked to you about. I'm asking what questions you answered for the affidavit. What were those questions? Basis of privilege. Robinson's testimony is that he spoke with General Counsel Gallagher about the affidavit. Questions directly seek communications between the Deputy General Counsel Gallagher and Robinson for the purposes of preparing the affidavit, namely what questions General Counsel Gallagher asked or provided to Correctional Sergeant Robinson to assist in preparation of the affidavit. So,
I mean, for example, if they asked, "What did you review?" Even if the lawyer told them to review it, it's not privileged. So, what were you asked to do? I don't know. You know, it's
I like,
Hmm.
yeah, I don't know either. I don't know. Like what I'm trying to figure out from the defense side of it is, I mean, obviously there's gaping holes for us as observers because we don't know what they're hoping to get out of these answers. You know what I'm saying? What I'm having a hard time putting together is exactly what the hope is with respect to these answers to these questions. Like, you know, like what is the attack? Like how is it helping the case in chief? Like their case in chief. You know what I'm saying?
The
Like, can
state
you
does not have work product privilege with its witnesses. That's absurd.
right. So this is, oh, are you talking about on the state's response
Yeah,
to
this
this?
I'm looking at, yeah.
So this is McClelland's response. The state believes the information the defense is asking the court to compel is privileged information as it is work product or pertains to communications with the state and one of their witnesses, or it is not relevant to the guilt or innocence of Allen. See, I mean, this has to be hearkening back to the argument, the broader argument that um, Allen's confessions were involuntary. Like they all have to be trying to build that argument. Like it's the only thing that makes any sense to me, you know, because it's like they're making the argument that obviously it was custodial. I mean, he's clearly in custody, but that these weren't interrogations. That he was never like Allen was never interrogated, and Rosie has made like the broader argument that everything that they were doing is akin to constant interrogation, like that all the shit that they were pulling, like the conditions of his incarceration, you know, all the stuff that was going on with him, that none of it, that it all amounts to the equivalent of it, him being interrogated, which thereby makes his statements involuntary because it was a 3-month period of time where, he's obviously not in his right mind. This is like the eating the fecal matter and, eating paper and, running into brick walls with his head. I mean, like he's doing shit that, like, if you're right in the mind, you're not doing, and like this concept that people are saying that, um, that Alan's some kind of criminal mastermind and he cooked up this whole malingering thing to go to those lengths in order to get still like that argument doesn't make any sense because if the point is to get your statement like it's happening at the same time that he's making these confessions. So like those two things contradict one another. So what, he's a criminal mastermind trying to act like he's nuts in order to
And then confesses.
exclude the confessions that he's making
Why
contemporaneous to the
right.
time that he's doing this
Why
shit.
make them if you're doing
Right,
all
like,
that to pretend that you're too
it
crazy
it doesn't
because you
make any
made them?
sense. It doesn't make any sense. It doesn't make any sense. Yeah, it really doesn't. All right, so that adds to the August 10th, 2023 deposition of Jerry Holman. Substance of the conversation had been between Liggett and Holman while the prosecutor is present to discuss trial strategy as work product and therefore confidential. Do you buy that?
Well, I think that no, not based on just what he said right there. That was the thing that I'm like, no. Because his thoughts that he's writing down, are one thing, but I and I'd have to go back and look at the damn question that he's referring to there, but as a as a general proposition just standing on its own, my answer would be no. Without more.
Right.
Excuse me.
Did you sneeze?
I did.
Oh, bless you. Okay, that as to May 3rd, 2024 deposition of Jerry Holman, the decision of when to hire a blood spatter expert for trials at the discretion of the prosecutor. And not only is Jerry Holman not in a position to answer that, but the state's strategy as to when to hire a blood spatter expert is work product and is confidential.
So now on this one, what I suspect the defense is going towards is how many other damn blood spatter experts did you guys consult before you got one that would agree to say what the hell you're putting forward now? I think that that it could be what they're probing to see. Were they having difficulty finding an expert to say what it is they wanted them to say? Um, and then you get in a situation where prosecutors don't write things down so they don't have to turn things over. So could there have been some Brady material, just meaning information favorable to the defense that was not documented, based on a discussion with with an expert who's like, I'm not going to be able to opine that. That's too, that doesn't really fit right, or that's not something that it works with the science, something to that effect. And that's what I think they're getting at there, although I don't know. So yeah, technically when to decide to hire a blood spatter expert, that is up to the prosecution. It's not up to Jerry Holman. He's got nothing to do with it. But to be able to ask him under the background that I just set out is a different thing.
I agree. I mean, I think as far as like Holman would have no idea why or when the prosecutors are retaining a spatter expert.
Right, but if they suspect that there was some conversation like, we need to come at this a different way because we're not getting an expert to say this." You know what I mean? Like, if somehow he was privy to that information, even though, the decision to hire was the prosecution's, if he's privy to the fact that they had some difficulty finding someone to say what it is they wanted them to say.
Travis is saying, read that exhibit. Which exhibit? Did I whip through it? I'll check it out. It's got to be one of the two. I don't know who Travis is talking about. That
I
it's
think he's talking
privilege
about the other, the DOC,
for
which
Gallipo.
I think unless he's trying to talk about number 1 up there, that them their discussions about, uh no, because 'cause they're talking about work privilege. Yeah, I do believe that their discussions with their lawyer, with the DOC, is attorney-client privilege, but it
Unless
just
there's other people in the room.
right, and like I said, just because an attorney tells you to review this information, that's not privileged. What information did you review, no matter who told you to review it, you know? But maybe he is talking about a, exhibit that was on the, the transcript. Oh, yeah, you kinda pulled it up, and then you moved away from it.
Oh, because I was trying to find the actual motions
We'll
before.
go back to it after we finish this one.
Yeah, we'll check it out. Um, okay, so that adds to the March 22nd, 2024 DEP of Gallipo conversations between Gallipo and the attorneys for the DOC are confidential as attorney-client communications. That adds to the April 18th DEP of Robinson conversations between Robinson's attorneys and his attorneys as are confidential as attorney-client communications. And that adds to the May 3rd DEP of Liggett. The purpose of the Unified Command meeting is not only not relevant to the guilt or innocence of Richard Allen, but also confidential as the prosecutor is involved in those conversations.
No,
Included work, but no way.
no,
Like this
uh-uh.
is like that. There were multiple people in that room. Like Travis, you know that there's no way. You don't have like if you have multiple people in there, it destroys privilege.
Well, he's talking about work product, and that's not his work product, that's the work product of the unified command, even though he was involved in it, doesn't change
Oh,
what
right.
they were doing. If
Yeah,
he
that's
took notes about his thoughts on it, "Well, I think unified command should have done this instead of that." Well, that's work product,
for
but
sure. Yeah, but what they did, the UC is
yeah,
done.
him being there doesn't change any of that.
Okay, so that as of the September 13th, 2024 DEP of Mullen answered the questions the defense posed to the best of his ability. Simply because he did not answer them the way the defense wanted is not a valid reason to ask the court for intervention.
So he didn't make the argument that Bob and I were saying, like, that question didn't really, it called for a conclusion and, he just said, "Yeah, he answered it." Just because they didn't like the answer doesn't mean he didn't answer it. But
So it
that's
looks like
not
there.
correct either. You can't skate around an answer and say you answered it.
All right, so these I think these are. I've only got two exhibits. It looks like so. Rosie was asked questions. Let me hand you what's been marked as defendants A. Is that document? Is it a document that you recognize? Yes.
Yes, I'll do
Uh,
the answers.
okay. Then an affidavit basically that's signed by you.
Correct.
And do you mind if I step over there just because I don't have a copy because I only made two? So did somebody interview? This was before you signed this.
Did somebody interview?
Who prepared this affidavit?
I believe it was legal.
You mean like the Department of Corrections legal?
Correct.
Could it have been Miss Gallagher, maybe?
Possibly.
I've been talking to her a lot.
Possibly.
And then it sounds like you can read that lawyer there.
So this is likely a lawyer for the DOC. I'm just I'm just gonna ask that there not be any questions about the conversation that Miss Gallagher provided.
I might ask one. You can object, but I appreciate you pointing that out. So you didn't prepare this. You didn't type this up.
No,
Do you know who typed it? Do you know for sure?
I don't know who typed it. I did have a conversation with legal about this.
Did your conversation, was this like a 5-minute conversation? Was it a meeting?
It wasn't a meeting, it was a conversation
Phone call?
in person.
And so how did this document get to you before you put your John Hancock on it?
I think it was. I'm not sure if it was addressed through concerns after the patches were discovered. I don't know if someone asked for it. I don't know if your firm asked for it. I'm not sure exactly why it was prepared.
You didn't ask to prepare it?
No,
I'm gathering that.
correct.
Did you send an email to anybody with a bunch of bullet points that are similar to the numbers here?
Nope.
The questions I asked earlier, forgive me if I didn't understand the question. How did you get this document before you put your signature on it? Was it an email attachment? Was it handed to you?
It was in person, I believe.
And so what were you asked to do when you got the document?
I'm going to object to the extent that it involves a conversation with DOC attorney. If your answer involves that, I'm going to instruct you not to answer. But if it's something other than that, you can answer.
Okay, so Rosie says, I shouldn't have cut him off, but I did. I just asked you a question and you were going to tell me the conversation you had with the DOC lawyer
Correct.
and then certify the question, Rosie says. Okay. And this is the other one. And this is relating to the phones. So, question, so it begins with bringing our phones in. You knew that we were bringing our phones in from the first time that we were there to see Richard all the way up to and including April 3rd of 2023.
I knew that permission was granted for you and Brad to bring the phones in. It's typically no phones are allowed, so special permission was granted.
And I understand that. And my question is, you were aware that we were able to bring our phones in from December of 2022 all the way up until April 3rd, including April 3rd of 2023.
I'm not sure the time frames. I just remember that you were allowed to bring your phones in at one point, and then that decision was overruled, and then you weren't. I don't remember the time frames.
Who overruled the decision that allowed us to bring our phones into Westville Correctional Facility?
I think that decision was to revert back to what the policy was and no phones.
Who made that decision?
The dog's crying. I believe legal.
Do you know why they made that decision?
I'm going to object and ask you not to answer if it involves something that you were told by legal. I'm going to go let the dog in here.
Okay, certify that. All right, so I think that was all. Like, I don't think we care about this last one. So ultimately, I don't think that Gull has ruled on these yet. And again, like I don't necessarily disagree with McClelland here in terms of I don't know how them being able to bring their phones in is relating to the case, the underlying case. So I don't know. I just don't know. All right. Okay, so I'm gonna. So what? Like, I don't get like when you're this short on time. I just don't. I don't see what the point is of like fighting this shit. Like, what am I missing? Like, what is? You know what I
I don't know.
mean?
It can't be in their mind, but it could be, like I said.
I mean, these are recent filings. There's got to be something that they want. Like, there's got to be.
I think the first thing you said is definitely involved here, like the conditions that led to him getting, like how he was being treated in there, and that it kind of shows they were going out of their way to make life difficult for him. Who knows? You've got some of that in there. Again, that deals with the confessions and how they came about and his mindset before that and how they were treating him. And they must think that something's awry, you know, with the blood spatter expert, but it could have been something like, shit, our case isn't as strong as we thought it was. We need a blood spatter expert. And that isn't something that is discoverable. Like that is their, you know, like just their strategy. If they just decided, what, this is going to make our case stronger, or if they, you know, had their own internal thought that it was um not as strong as a case, and so they needed this expert. But it seems to me like they might think that there was someone else consulted that kind of said no.
Yeah.
But who,
They're right. They're obviously trying to they're trying to establish ultimately you know, and I typically don't bring up murder sheet, but like when I heard them saying that the defense didn't really put an argument forth with regard to trying to have the confession suppressed, and they're just dead wrong. It's like when they say things like that, I just, you know, it becomes evident that they don't understand the law, you know, and like but these, no, it's true,
I
and
mean, they're
I'm not
dead wrong
saying
about
it
a
to be.
lot of shit. That's the only reason I'm, and I don't
Nah,
even
well, like,
wanna.
I don't even wanna get into, like, the rest
Right.
of it 'cause I don't give a shit, but, like, in terms of, like, when they say things like that, they go on the prosecutor's thing, they're like, "No, they didn't make any kind of argument." I'm like, "Well, they actually did." And like, to me, that's what this stuff is going to, which is they're essentially trying to get at that there was a full court press by the prosecutors, by unified command, and by the people in Westville to squeeze Richard Allen to get him to talk, and that it was a concerted effort. And that's what they're trying to show with this. That's why they're trying to get these answers, that this wasn't your typical, I'm going to take the light bulb, you know, the swinging light bulb, and then blast it in your face and grill you for, you know, 48 hours straight. What we're going to do is we're going to work you psychologically
Grind you
for
down.
months
Right.
and months and months, and that it was a concerted effort, and it was the exact equivalent of a cop shining a bright light in a guy's face, not allowing him to sleep for 48 hours, and consistently hammering away at that person until they break down and make some kind of a statement. So I don't know. I mean, like, that's obviously what
What do you want?
they're trying to establish, I think, with this stuff, which is really, I think, like Brad's area. Like that's going to be where Brad is. Thank you, MS Waller. Appreciate that. Um, so like, look, all right, and like, kind of end this thing tonight. We're getting on 2 hours. I don't want to go too late tonight. We will be back tomorrow with Bill Dorsch. Bill met me in London. We have another guest lined up for the Guevara stuff. If you guys are not hip to the Guevara stuff, and you guys are one of those people who just think that law enforcement never lies, cheats, and steals, and that they're always on the up and up, I'd suggest watching this stuff. The Guevara stuff is mind blowing. It really is. And it shows how scary it is when you have corrupt cops with that much power out there, and the lives that they can ruin. It's devastating. It's unbelievable stuff. So that'll be tomorrow at 9 p.m. I want to thank everybody for the supers. Thank you so much. Vonda K, Dr. Vonda, we love you so much. Thank you, thank you, thank you. Always. You gave a few times tonight. Dom's mom, we love you. Gifting a DD pod membership. We appreciate that. Gifting a few of them. Did it a few times. T, we love you over at Criminality. Make sure you're subbing to our girl. We love you so much. Marissa, welcome, welcome, welcome. And y'all, if you haven't subbed, we'd appreciate if you do. We're growing the show. Sub, share, like, all those things. They really, really help. If you're on Replay Crew, make comments, interact on the videos. It gets it out into the algorithm. It's all very helpful. Spitfire, we love you. Thanks for being here. Kasha, what's up, girl? Haven't seen you in a bit. Not DB. Let's listen to Ethical Lawyers. I don't know if you're implying we're not. Sounds like this is a murder sheet mole. But I think that let's listen to Ethical Lawyers discuss law, not to mention the ones that practice.
Maybe she's
Subscribe.
talking about us.
Who? I know. Subscribe to Potentially Criminal. That's my friend Sean. So I think Sean would.
I don't think
Sean,
that I think they are saying we're ethical lawyers. I mean, we practice law. So I don't
yeah,
know.
right.
Can't be talking about us.
I mean, yeah, I wouldn't think so. You never know though.
But I do
But
want to mention
do,
I just did my thing and where I check and we got like half the people. We got 263 likes and 460 some people.
yeah, hit
So
that like, hit that like.
that like
But do
that like.
subscribe to Sean over at Potentially Criminal because I love him. He's great. All right, Forrest came through. $20 haul. Appreciate you. Second Hook member for 11 months. Thank you so much. Missed you guys. We missed you too. We missed you too. It was great to get the break, but it's great to be back too. And then Dr. Vonda again came through a couple times. Desiree D. Hey, can't type driving. No bueno on refusing AV. Agreed. Hard. Tammy Martin came in late with the $20 holla. Appreciate you so much.
Thank you.
We appreciate the support. We really do.
And don't forget, we're gonna do a primer. We're gonna have, Melanie on, so if you haven't subscribed to Attorney Melanie Little, you should do that. She's great
Definitely.
as well. She does really great coverage, and we're gonna get her up to speed on this case because she's been spent all her time on all the details and everything Karen Reed. So she's not as up to speed on Delphi.
Yeah. Yeah. Uh, oh, the Venmo handle. Yeah. Yeah, we don't have Dizzy in here throwing our Venmo. Can any of the mods throw the Venmo handle up there? I thought we should have that pinned at the top anyway. Or it should be in the chats. But the Venmo handle
Thanks,
is
Dawn. 10 months.
10 months is a long time. That's a long time. That's almost like OG. Like I think our end OG. This is Venmo. If anybody ever wants to send Venmo, we love Venmo. Venmo's the best. It's boom. This is it. That's that. So you got any closing thoughts? Because like what I wanted to do also, and I kind of got sidetracked with the filings, is I've been watching some content, not much, from other creators, and it seemed like people didn't have an understanding. The thought was from a couple people that I saw that they selected jury long before trial starts. No, it's like selecting a
Usually, it's the
juror.
day of jury. Here,
Yeah,
they're starting
it's the
2 days
beginning of the
early.
trial. It's like once you start selecting your jurors, and once they get them impaneled, boom, that's it.
Double
Like
jeopardy attaches. That's it.
jeopardy
Gotta go.
attaches, and you're off to the races. So, yeah, no, this is just like they anticipated. It'll take a couple days, get a jury selected. Obviously, they sent out pretty long questionnaires, and they're gonna have to pick and choose, and they really do want to try. Oh, Venmo just came through. That's awesome.
Wow.
Whoa, $50 from Brianna. Thank you,
Thanks,
thank you
Brianna.
so much, Bri. $50. Love you guys. Thank you. Thank you. That was incredibly generous. We appreciate that so much. Yeah, and I want to get Travis on here too. Travis is amazing. I was just
Yes,
thinking
we
about
I think that's what I'm saying. I think we do a macro primer, and then we do, like, a micro primer because we're not gonna be able to do both those things at the same time.
Yeah, Travis is definitely the micro.
Right. Yeah.
Yeah,
And,
definitely.
well, because
He's
like I
that guy.
said, Melanie's gonna, she's gonna play to the listeners who don't have all the details on Delphi and, ask the questions that you know, come to her based on what knowledge the limited knowledge she has and what we're gonna be going through. So it'll be helpful for someone to be like, "Well, wait a minute, how does this play out?" Plus, with her being a lawyer, her questions will be very, relevant and geared to better
For sure.
understanding it all.
For
So,
sure. Dr. Vondo, what docs? What docs are you talking about? I don't know. I don't know what you mean. Oh, Mama. Gritty. Member for 10 months. That's awesome. But yeah, so like once voir starts, it's like really the beginning of any trial in terms of picking your jury. And then after that, the state goes. And when we get into our macro, I think that's when we'll kind of probe into trying to figure out how the state's going to put this case forward. And at that point, we'll kind of go through and try to read the tea leaves and see what the defense can do with what they have left to put on in defense. We'll kind of go through proof of life witnesses, proof of death witnesses, what they need to establish to meet their
thanks,
burden
Travis.
on the state side, and what the defense can try to do in order to try to rebut that case on their case in chief. So it'll be good. We'll keep you up to date. But again, tomorrow, there's really no trials going other than YSL. Like I've been tinkering with the idea of streaming some of the YSL. Like today, the judge just lit up
Do we even know
prosecutor.
what she decided when she came back?
I have not seen that she granted a mistrial.
Mm.
So, grandbaby is amazing, Susan.
Oh,
Thank you
yes.
for asking.
She was over yesterday.
They got a full day. I was at the Bears game. So I only got like kisses on the head because they were trying to put her to sleep. So uh
Grandpa got screwed.
I got
Fun
screwed.
pa.
Fun pa, fun pa. So yeah, it was a good Bears game. It started horrible. I was wanting to jump off the top of the stadium and just call it a day because I couldn't stand watching it like in the first quarter. So, but they righted the ship. They ended up taking it down. But yeah, the YSL was crazy today. Nay. All right, you guys, it's been real. We love you. Thank you. We've missed you. Thank you. Thank you. Thank you so much. Make sure that you like, make sure you're sharing, make sure you're subscribing. It means everything to us. We're really trying to grow the channel. We're back. Your support, when you guys give us, supers, when you buy memberships, it's such a huge support to us in terms of keeping this going. Because if you're
But
putting
a
in
like is just as valuable, so don't forget to like
it's
and
not
share.
that like
Alright,
not
come on.
quite as valuable. It's pretty valuable though. It's not quite as valuable, but it's valuable for sure. It definitely
No,
doesn't hurt. That helps get us out to the world,
it does.
and then the financial support helps us keep the lights on. So that's big for us too. Um, Don Burke with a little late love. 10DD podcast memberships. Thank you, Don. Always give her. We appreciate you. All right. So that's it. You got anything else, babe?
Nope. Bye, guys.
All right, y'all. See y'all tomorrow.